Okay, I want to show y'all some of these forms, y'all. I'm gonna start off with some of these forms in probate, and I think I'm gonna stop beating down the probate court thing and start talking about some other stuff, because I think I proved my point over here on this stuff, and I don't want to bore y'all with the same old stuff. As you see right here, this is just Georgia right here, but you can type in your state and find out. You can see that these all of them have the same these standard forms. Okay. And general instructions. This is the form. It has general instructions. This to tell you what needs to be put, in the forms or whatever. But the reason I'm showing y'all these forms is to show y'all that when first and foremost, the jurisdiction all starts with probate. They get all public officials. They all get their power starting off at probate court. Okay. It starts. Remember me. If you go back and look at my video where I talk about letters of administration, this is what they have to accomplish. This is what they have to be issued. Any judge has to be in order to administer your estate. They have to petition probate court to receive these letters. That's what gives them the power to administer your estate. Keep in mind, the only way you can administer someone's estate is if they're presumed dead. That's where the Sesta KV Act of 1666 comes in at. Remember, all states do this. All of them have different number of years. Cut this damn volume down. The default number is 7 years according to the Sesta KV Act of 1666. But not all 50 states do 7 years. Here in Georgia, as I've said before, it's 4 years. In Florida, it's 5 years. In California, it's 5 years. North Carolina is 7 years. Social Security Administration is 7 years. So, but all these entities do that to some degree. Now, I'm only saying this stuff without showing you what I'm talking about, because I've showed it to you in videos already. And if you gotta go back and look at the other my previous videos, and I'll show you everything that I'm telling you now verbally without clicking. I don't have to show you the same thing every single time I do that, because that kind of makes things a little repetitive and it's unnecessary. That's the purpose for other videos. Now, I'm showing you these forms because these forms are different things that they're trying to get power to do inside, concerning your estate. Okay. Now, this is so it's when someone either has died or they're presumed dead. So it don't necessarily mean you're dead if somebody is established how can I say administering your estate. You can just be missing. There's no record. There's no presumed dead. Some states they say missing person. Some of them say presumed dead. Some states they just word it differently. Here in California, they say some of them say absentees. Yeah, I think California they say something. I'll show you in a minute what California says. And I want to use California this time because I was just on the phone with a friend of mine who's dealing with a whole lot of bullshit when it comes to even his kids, custody of his kids, different legal stuff they got going on. And he's suffered a lot of brain injuries dealing with this situation concerning child support. Okay. And I've been talking to this guy since 2019 when I had my old channel. And it gets kind of frustrating talking to him because he got to detox some of the stuff he's been hearing on the internet and not really listening, Anyway, start listening to some of these people on the internet that's teaching stuff that they're not showing you nothing in the laws. They just kind of, giving them a bunch of word salad and selling them processes. Petition for presumption of death of a missing. Look at that, missing individual believed to be dead. See right here. This is a petition. This is a form right here. This is a form. Petition for declaration of death of a missing individual believed to be dead. Not proved to be dead, but believed to be dead. So imagine them having to do this. They have to go through this process to presume that you're dead. To be dead. And matter of fact, let me read the purpose of this one here. This form is to be used for petition for declaration of death of a missing individual believed to be dead, pursuant to Georgia OCGA 53-9-1. Now, if they want to presume them dead, they want to get this is what they want to declare. They want to have they want probate court to declare my death simply because I'm missing and they believe I'm dead. Not that I'm proved to be dead, but they believe I'm dead. They want to believe that I'm dead. I can go before the court. I can show up in court and they be like, state your name for the record. And you state your name. That's proof alone. I'm standing here. You look in my damn eyes. How can you prove? They're gonna go by what's on paper? If this is granted to them, then that's how they get the declaration granted. You know what I'm saying? Based on an individual, a missing individual believed to be dead. They want to get a declaration, even if he's not proven to be dead. Okay? And according to Georgia, if you're missing for 4 years and it's 4 years straight, then they be like, okay, he's presumed dead. That's what this code right here says. I showed this to y'all in a previous previous video. They presume you to be dead if you've been missing after 4 years. Okay. Basically, if I'm 4 years old, at the age 4 years old, and at any point where they ain't heard nothing from me, if after 4 years successively, they're gonna be like, oh, we can do a petition, presume he's dead. You know, I don't have to keep up with y'all in order to be proven I'm alive. I don't have to talk to y'all at all. But at the same time, this is what's on paper. Okay, so once they get the declaration granted, now you're declared dead. Even if you're not dead, you just believe to be dead. They can still get a declaration if they can't find you or whatever, and they can't prove that you're alive or whatever. You can just be totally under the radar. Under the radar, and they don't even know you or where you at. They just we're gonna go with that presumption. Sometimes I'm sure I don't even think they do a search for real. I don't think they do so. Especially if you got lights and light bills and all the different stuff going on or whatever. I guess by that time you already presumed dead anyway, because keep in mind it says after 4 years. Hell, you probably done that after you was 4 years old. Anytime after 4 years old, there's no evidence that you're alive other than anyway. I think it's some bullshit myself, but that's what they do. Now, this is something I wanted to show you, right? This is California. I got off the phone with this guy and I had to show him this is what they do right here. Once they receive those letters of administration, say subject to the provisions of this part, in the state of a missing person may be administered in the manner provided generally for the administration of for estates of deceased persons. So they can administer, they can be granted letters of administration to administer your estate simply because you're missing. The state of a missing person may be administered in the manner provided generally for the administration of estates of deceased persons. You have nothing on the record proving that you're alive. You're operating as a dead fiction. You're operating as if you're dead. Civilis mortuus. Let me see if I can look that up. I don't even know how to spell that. Civilis mortuus. How do I spell that? Make sure I spell it right. Civilis mortuus. There it is. I was right. Civilis mortuus. There it is. Mortis. Wrong thing, Mike. Clicked on the wrong thing. Mortis. Civil death. Civilis mortuus is the loss of all or most of all civil rights. Keep in mind, civil cases by a person due to a conviction for a felony or due to an act by the government of a country that results in the loss of civil rights. See, it says or. That's the key word. Or. Due to an act by the government of a country that results in the loss of civil rights. Okay, so your name, and this is the Black's Law Dictionary. I was reading Wikipedia, but this is Black's Law Dictionary right here. The condition of one who has lost his civil rights and capacities, and is accounted dead in law. When your name's styled in all capitalized letters, that's what. Look, read everybody's tombstone, and anybody's name written on a tombstone, you see their name is styled in all capitalized letters. We've heard that a million times, but that's exactly what they're doing to you. So you're operating as a dead fiction. You're acting as a dead entity when you're in their courtroom, representing that name instead of taking control of the name and stating who you really are. Okay? You have to have on the record who you really are. You don't need to be in there with nothing on the record. If you ain't got nothing on the record and you just in there, you're going to get your ass handed to you. So I wanted to show y'all some of these forms. Now, back to these forms right here. Remember, I just clicked on this one. Let's see. See, a minor ward petition to a compromise doubtful claim of a minor or adult ward, an adult ward, like somebody that's mentally incompetent or something. Y'all know what a minor is. Let's see. Lisa and Cross Corpus. Let's see. Bond. See, these different things to serve different purposes that they use to administer your estate. Guardianship of a minor. See, conservatorship of a minor. They get the power to do all this shit based on probate court. All this stuff comes from the petition and probate court to do all this stuff. Okay, and they first have to get letters of administration to even do any of the stuff that they're doing. You have to first receive letters of administration. This right here. It's a petition for termination of guardianship, / conservatorship and restoration of rights. This is like, I read this already, so I'm not going to click on it. This is where it's talking about, they say is you got somebody that's they mentally slow or whatever, and they get a check or something going on with them mentally, and they need somebody, an overseer, to oversee their money to make sure they don't get taken advantage of. For whatever reason, they only have to be slow, like mentally incompetent. They don't have to be like, I don't want to use the R word, but y'all get what I'm talking about. But they can, if they were in a coma, let's just say that. Say they were like in a coma or some type of mental disorder due to some freak accident or something. And once they get back to normal, they got their senses back in order, they're able to make moves on their own. Now they can actually have that stuff terminated, and they can start doing things for themselves, and they can terminate that order for that person to be an overseer. So, but you see, this is what they do right here. All this stuff starts with probate court. Okay. Now, I'm going to show you. I don't want to get on presumption shit. I've already been on presumption. I done beat it over the head already. Now, let's see. I already said that already. But I wanted to show y'all. I just wanted to show y'all that because I don't want this video to be long like all my other videos. Because y'all know I generally don't do long videos. But this is how they obtain letters of administration. But a matter of fact, I think I will go to this part. What was that? What was I looking at that time? Here we go. Let's see. What was I? Appointment of. See, I'm trying to show y'all how the judges get the power that they have. Okay. This is California, of course. I'm back at California. Administration of estates of decedents. Keyword decedents. That's someone who's dead. Okay. Y'all already know that. Most of y'all do know. If you're a beginner, we're gonna show you anyway. Okay. Legal definition. So you see for yourself, the term is a term that is generally used in the law governing estates and trusts in reference to a person who has died. Okay, so when you see decedent, that's what they talking about. The administration of the estate of decedents. Okay. The public administrator of the county in which the estate of a decedent, there's that word, may be administered, shall promptly, says a petition for appointment as a personal representative of the estate. If no person having higher priority has petitioned for appointment, and the total value of the property in the decedent's estate exceeds $150,000. Petition for appointment as personal representative of any other estate the public administrator determines is proper. Say accept appointment as personal representative of the estate. So when so ordered by the court, whether or not on petition of the public administrator after notice to the public administrator, as provided in sections 2621. Priority. Proceed with summary disposition of the estate as authorized by Article 4, commencing with section 7660. If the total value of the property in the decedent's estate does not exceed the amount prescribed in section 13100, and the person having higher priority has not assumed responsibility for administration of the estate. Okay, keep in mind he talking about decedents. Okay, now let me go back. What was I doing? Go back. Administration here. Trying to see, I want to find something specific on here. Let's see. Letters may be issued to the public administrator of the county without naming the public administrator. Okay, and that could be the judge. Keep in mind, judges are administrators. They administer their people's estates. I'm gonna say people's estates. Okay, they administer your estate. They're known as administrators. Except as otherwise provided in this section, appointment of a public administrator as personal representative shall be made, and the letters of administration I'll tell y'all about issued in the same manner and pursuant to the same procedure as the appointment of and issuance of letters to personal representatives generally. Okay, appointment of the public administrator may be made on the court's own motion after notice to the public administrator as provided in section 1220. Now you notice, when you go look at a court case, you don't see any of it. You don't see letters of administration nowhere in there. Like, you don't see what they filed in there to give them power to do this stuff. This stuff is done in probate court, as you see right here. This is in the code. This stuff was done in probate court. So say if they're saying that, the judge is administering a court case, he's presiding over the presiding judge in superior court. That's a different court. So what was filed in probate court don't have to be filed in a superior court case. You know what I'm talking about? Now, so let's go back. I got to keep that in mind too when I rebut the presumption they're talking about as well. Let me back up. 22. Let's see. Public administrator. The public administrator shall administer the estate in the same manner as a personal representative, generally, and the provisions of this code concerning the administration of the decedent's estate apply to administration by the public administrator. There's that word again, decedents. Okay. Now this also applies for someone who actually is dead. Okay. But you just saw for yourself, and I'm not going to read this whole thing because I want to kind of shorten this up a little bit. I'm already almost 20 minutes already. But I want to go back to once they receive those letters of administration, it says subject to the, keep in mind, we still in probate code. They still in probate. Say subject to the provisions of this part, the estate of a missing person, it may be administered in the manner provided generally for the administration of estates of a deceased person. You could be missing or deceased. Either way, they're going to administer your estate. You ain't got no proof on the record. Now, you got no proof. You haven't rebutted the presumption of your death, and you can actually do that in private, on the private side, without filing. Anyway, let's see. I'm going to type something in here real quick and show y'all. It was something I wanted to make sure I see what they call presumption of death since we're in California. Nope, I don't do law attorneys. I don't do attorney form. Let me see. In proceedings in this part, keep in mind we still at probate. This is the code that came right before the one I just showed y'all. See, that's 40. See right here when I was talking about the missing person, they can administer your estate as if you're dead. That's 12402. This is 12401. Okay. In proceedings under this part, a person who has not been seen or heard from for a continuous period of 5 years by those who are likely to have seen or heard from that person, and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed to be dead. So I'm talking about, you ain't proved to be dead, but you presumed to be dead. First they petition probate to get a declaration that you're dead, even though you're not dead. And then say the person's death is presumed to have occurred at the end of the period. They talking about the 5-year period. They talking about right here, the period of 5 years. Unless there is sufficient evidence to establish that that death occurred earlier. So if there's no evidence there, they're gonna presume that you died after 5 years. Okay, so now they kill you off after 5 years. Just imagine them. They got you presumed to be dead at the age of 5. And you were born in California. You presumed to be dead at the age of 5. It's crazy as hell. So at that point, you're presumed to be dead, and you ain't got no evidence to prove that you're not. Now you know they're gonna still. This is crazy. It's to me it's a mind fuck. You ask me, but that's what they're doing. And as you see, the following thing right here say you missing. You say your estate may be administered in the manner provided generally for the administration of estates of deceased persons. So they're presuming you dead. That's what gives them the power to administer your damn estate without you damn knowing. I mean, you not knowing what they're doing. They got it right here. They're telling you what they're doing to you, but you got to rebut the presumption. You have to rebut the presumption. Matter of fact, let me see what 12402 says. I mean 403. Let me see what it says. Let's see. Presumed dead or missing. Say if the missing person was a resident of this state when last seen or heard from, the superior court of the county of the person's last known place of residence has jurisdiction for the purposes of this part. Say if the missing person was a resident of this state when last seen or heard from, the superior court of the county of the person's last known place of residence has jurisdiction for the purpose of this part. Say if the missing person was a non-resident of this state when last seen or heard from, the superior court of a county where real property of the missing person is located, or the property or the county where personal property is located, if the missing person has no real property in this state, has jurisdiction for the purpose of this part. See, bottom line, they're able to administer your estate because you presume missing. They use the word missing in California. In Georgia, they use the word missing. This is California, right here. Georgia, they say missing as well. Some states say absentee. You know, you're absent himself. That's what they use. So it don't necessarily mean you missing like somebody kidnapped you. Well, that could be one too, but there's many ways to be missing. They're showing you that. They're explaining all of this in the codes. Okay, let's see, 403. Say if the missing person, I read this part already. Seen or heard from, yeah. Let me go to 404. It's all about reading this stuff, y'all, to get some clear understanding. A petition may be filed in the court having jurisdiction under subsection 12403 for the administration of a state of a missing person. The petition may be filed by any person who may be appointed as a personal representative other than the person described in subsection R of 8461. 80R of section 8461. In addition to the matters otherwise required in a petition for administration of estates, the petition shall state all of the following. This is when they're trying to get letters of administration. Okay, This is where they're trying to get. They're trying to get those letters of administration. Said the last known place, address of the missing person, the time and circumstances when the missing person was last seen or heard from. That the missing person has not been seen or heard from for a continuous period of 5 years by the person likely to have seen or heard from the missing person, naming them and their relationship to the missing person, and that the whereabouts of the missing person is unknown to those persons and to the petitioner. Say, this is why it's good to do things on the private side. When you're doing things on the private side, you are showing up as a living man or woman. But if you go in there showing up, acting as the all caps name, the name in all caps, that's civilist more too. You have no rights there, and they can move at their discretion. That's what I'm trying to show y'all. As long as you're operating as that fiction, you're operating as the estate itself. They have the right to. That's what gives them the power to control what it is, your destiny, what's going on in the court case. Notice of hearing. See, they do all this stuff as if they're trying to go through this process to obtain letters of administration, so that they can administer your estate. Said this already. It said hearing, court, satisfied, diligent search. And then they go through the whole search, the whole process. This is what it's all explaining. How they all went through this investigation to make sure they did diligent search to find you. If the court finds that the alleged missing person is a person presumed to be dead under Section 12401, the court shall do both of the following. Appoint a personal representative for the estate of the missing person. I need to take me another Alka-Seltzer. This is what happened when I did 40 minutes in the damn sauna instead of 20. And then I slept with the ceiling fan on. Butt ass naked. I gotta stop doing that shit. Number 1, appoint the personal representative for the estate of the missing person in the manner provided for the estates of a deceased person. See that? In the manner provided for the estates of deceased persons, and you just a missing person. For the estate of a missing person, it's the same thing I just showed y'all where's that other one? Anyway, no, I ain't gonna. Y'all saw it already. Determine the date of the missing person's death. The personal representative shall administer the estate of a missing person in the same general manner and method of procedure, and with the same force and effect as provided for the administration of estates of a deceased person, except as otherwise provided in this part. This is what's doing. This is how they're doing it. They're letting y'all know exactly how they're doing it. Let's see. If the missing person reappears, the missing person may recover property of the missing person's estate in the possession of the person's representative. Less fees, costs, and expenses thus far incurred. Say the missing person may recover property of the missing person's estate in the possession of the personal representative that was appointed to administer your estate. You can recover that from the personal representative. The missing person may recover from distributees. If something was distributed out to them to other people who made claims against your estate, you can recover that. Any properties of the missing person's estate that is in their possession, or the value of distributions received by them, to the extent that recover from distributees is equitable in view of all circumstances, but in action under this paragraph is forever barred 5 years after the time the distribution was made. So after you rebut the presumption of death, if it was done, your stuff was distributed out 5 years ago, over 5 years ago in California, you can count that as a loss. The remedies available to a missing person under subsection A are exclusive, except for any remedy the missing person may have by reason of fraud or intentional wrongdoing. Say, except is provided in subsection A and B, the order for final distribution when it becomes final is conclusive as to the rights of the missing person, the rights of the beneficiaries of the missing person, and the rights of all other persons interested in the estate. If a dispute arises as the identity of the person claiming to be a reappearing person, the person may make a claim, or any other interested person may file a petition under section 11700, notwithstanding the limitations of time prescribed in section 11700 for the determination of the identity of the person claiming to be the reappearing missing person. That's what somebody trying to claim to be you, and they trying to act like they're reappearing so they can benefit from it. So, but as you see, when you rebut the presumption of death, all this shit comes to a halt. It shuts down the personal representative. Whoever that is representing your estate, administering your estate, they can't do it no damn more. Okay? And I'm gonna make sure I go ahead and throw this in here like I did at the last video. The last video when I was that Ohio? That Ohio? What was that I clicked on? No, it wasn't. It was was it? Let's see. Administration of the states of a living. Yeah. That's exactly what it was. I think it was. Nope. What was that damn thing I clicked on and I see it? I got on off of there. Let's see. Was it Ohio? Letters of administration of an estate of a living person. Or was it Ohio? It's highlighted for a reason. Let me see. Administrator, removal of executive administrator. I might have to end it right here, y'all. I had to look for it even then. I forgot when I found it. Anyway, I'll probably just end it right here. It says living person is void. That's what I found in the last video. I showed it to y'all. I can't remember what state it was. Here it was. It was Texas. There where it was. The administration there it is. The administration of an estate of a living person is void. So you got something going on and you prove that you're alive. You shutting all that shit down. That's all y'all got to do. Shut it down. Okay? That's probate. All this stuff starts at probate. Get the root of the problem. The root of the problem is in probate. Okay? See, all these, these paper wars that we've been doing for years and not dealing with the probate issue. That's one of the reasons why with these wars, they take place for years, constantly going back and forth with their paperwork. Them ignoring this and ignoring that and trying to, they're trying to railroad you. They can't railroad you when you take the power from them. And all you gotta do is come alive. Prove that you're alive. There's many ways to prove you're alive. Affidavits. That's for the living as well. That's why it's good to deal with people in their private capacity. This is probably one of the reasons why every time I was getting, no, I ain't gonna say that on public forum, but this is one of the reasons why when I deal with people privately in their private capacity, the shit that I've dealt with that I had to run into in the public realm goes away. And I've done that like on 5 different occasions. But the thing is, now I understand why it was so effective, because the living does affidavits and they do things in the private. They do it in the private capacity, not as a fiction. You don't want to be all in their courtrooms dealing with people in their fictitious capacity. They're in their commercial capacity. Keep in mind, everybody in that courtroom that's not they're in there with the suits and their robes and stuff on, they're at work. You in there in your private capacity conducting business. You in there at their job. And you're acting as a fiction that's also on their commercial documents. And you're in there, you're acting as a fiction. And you're not, there's nothing on the record proving that you are anything more than that. And you have to rebut that presumption. That is the number one presumption of court that people don't even understand. I prefer to stay in the land of the living. It just kills all that headache shit that we got going on. And so that's probably why I keep making these videos about it. Because I want to keep showing y'all the different angles. And California ain't no damn different. I mean, California seems like a damn slave state. But y'all see for yourself. It shuts them down too. This is California right here. All these states are the same. They all telling you what they're doing, but you got to educate yourself on what to do. And it start off by reading. They're telling you how to play the game. This is the monopoly. This is the monopoly. These codes are it's like the monopoly board, the monopoly instructions when you're playing Monopoly. I'm gonna get them out of here. Emeralds signing out.